So good morning. Thank you for joining us on today's HR Masters webinar, Streamlining Remote Working, presented by Lil Ferguson and Toby Popram from our Sheffield employment team. We're also delighted to be joined by Emma Noble from Elevation Recruitment, as well as Emma Brooksbank, a partner in our immigration team in Leeds. Before I hand you over, if you've got any questions for the panelists, please put these in the Q&A function and we can go through them. If you've got any technical issues during the webinar, then please put them in the chat function and I can answer these. And I'll pass you over to Lil. Thanks very much.
Morning, everybody. Thanks for joining us today. If you, the sound's a little bit crackly. If you have any problems with the sound, can you just pop it in the comments or the Q&A just so we can know that everything's working as we go along. Anyway, welcome to our seminar, mostly looking at homeworking and some of the issues that arise from that. Before we get going with that, I just want to spend the first part talking generally around flexible working requests. I think many of you will have seen from your organisations that following lockdown, well, obviously there were newly established ways of working implemented in practice. There was an increase, or there has been an increase since then, in the number of requests from employees to work flexibly. I mean, quite frankly, a lot of them perhaps didn't think about putting in a flexible working request in the past, or just didn't think it would be accepted, whereas they've had a few months to trial it now, and they see that it is something that can be accommodated. So they are now putting in those requests on a more informal or formal basis. So how should these requests be approached if you are beginning to see them coming in? The first point to flag up is that there is no legal right to work flexibly, but there is, however, a statutory right to have a flexible working request reasonably considered. And I think people often confuse it, and a request comes in and thinks, you know, automatically you do need to say yes. It's a request to put in that request and have it reasonably considered. But the first point will always be, is it an informal or formal request? And you can treat the two slightly differently. If an employee wishes to vary their hours or place of work, it might be the case that you're able to agree arrangements informally, i.e. not going down the statutory route. There's no eligibility requirements for an informal request, so someone could put it in on day one. And it may be more appropriate in many cases for temporary arrangements. So, you know, especially in a given climate, perhaps someone who lives at home with a vulnerable family member and wishes to work from home temporarily, or perhaps someone who has ongoing childcare needs, maybe their nursery is still only has restricted opening hours or something like that. So they just want a temporary arrangement to try and accommodate you know, their different home needs. If you are getting in a formal request, in particular, so the one on a temporary basis, it is still good practice to record any such informal arrangements in writing. Just because it's an informal request doesn't mean it should just be verbally agreed. That can lead to problems if you are looking to only agree in person without writing it down, because, you know, memories fade, and it might be that a few weeks, months down the line, you recall the conversation very differently to your employee, and that can obviously lead to disagreement. So I'd always suggest that you have a clear written record of anything that is agreed, even if it's on an informal basis. And particularly, you know, if it is a temporary arrangement, make sure you're diarising the end date of when you expect it to come to an end, or perhaps a review date, you know, 2 to 3 months, where you're going to sit down and discuss with the employee whether it's still a change that they would like to continue going forwards. If you're not clearly having that discussion with the employee, or at least managing their expectations that it's a temporary change, there is a risk that if it continues on for, you know, 9, 12, 18 months down the line, that if neither party is doing or saying anything to suggest that it's going to come to an end, that the employee could argue that it's become an implied contractual right to have that continued, whereby they're saying it's not been expressly agreed by you as the employer, but the expectation on their part certainly is that it should continue to be complied with, and that has now become implied into their contract. So to ward that off, do make sure that you're having those ongoing conversations with the employee in terms of how long it's expected to last for that arrangement. So that's informal arrangements, but what about a formal request? So this is one that's put in under the statutory flexible working regime. For an employee to be able to put that in, they should have at least 6 months continuous service with an employer and not have submitted a formal flexible working request within the last 12 months. You can choose to waive those minimum requirements, but you don't have to. So you don't have to consider a request unless it ticks both of those boxes. The request should also be in writing, it should be dated, and it should state on the face of it that it is a flexible working request under the statutory procedure. The request should also specify and give the detail around the change that the employee is seeking. So, you know, you're in no doubt when you discuss it with the employee what exactly it is that they're after, when they wish the change to come into effect, what effect, if any, they believe that the change would have on the organisation, and how they think it can be accommodated in practice. So it's for the employee at the start to sort of set out their stall in terms of how they think that it is a workable request. And also, in addition, whether they've made any application to the employer, and if so, so you can check that they've not submitted one within the last 12 months. So again, all of those boxes should be ticked, and if they're not, you go back to the employee and ask them to provide more detail at the outset. So what do you do if you receive such a formal request? Well, you've got 3 months to make a decision, but that is the entire time frame that you're allowed and you'll comply with your statutory obligations. So it's not appropriate to receive the request and then schedule a meeting 2.5 months down the line, because that 3 months should include time to meet with the employee, make a decision, give them the opportunity to appeal, and then have the appeal outcome. So you should be looking to try and have that discussion with the employee as early as possible, because the whole thing needs to be done within a 3-month period. Obviously, and you know, again, this is, I'm sure, telling you something that you all know, but there's a duty to act reasonably when you receive the request. So unless you intend to accept the request just on the face of it, because it's clearly something that can be accommodated in practice, you should be arranging to speak to the employee about the request, and it is good practice under the ACAS guide to offer the employee the right to be accompanied by a colleague to those meetings. Clearly, you know, given the current circumstances, it may be appropriate to do this remotely, perhaps by a video conference, and that's absolutely fine. You know, a face-to-face meeting, whether it's remotely or in person, either one would work, but you should be making sure that that meeting is at least offered to the employee. So what if you want to turn down a request, which might well be the case, you know, if it's something that can't be accommodated? An employer can only turn down a flexible working request on one of 8 specified statutory grounds. They're all sort of sensible, common sense, you know, business reasons, but they do need to fall within one of those 8 reasons. So firstly, the burden of additional costs. So is it simply just going to be too expensive for your organisation to be able to accommodate it? Would the additional recruitment costs, etc., be disproportionate? Secondly, a detrimental effect on the ability to meet customer demand. So perhaps they, you know, if you're a retail organisation, your highest volume sales day is a Saturday, and they want to have every Saturday off, and that's primarily when you need them. You know, you simply won't be able to service your customer demand if they're not there. An inability to reorganise work among existing staff. So this is perhaps particularly pertinent if you've got a smaller team, and it would just place, you know, an undue burden of the staff that have to get them to cover the working time when the employee wants to be off. An inability to recruit additional staff, you know, if they maybe just want every Wednesday off and you need to have those Wednesdays covered, is it simply not practical to have someone just on a Wednesday to do that job? A detrimental impact on the quality of your service or on the performance of the employee. So the latter might be particularly relevant if it's someone who needs performance managing a little bit more closely at the moment, and you're concerned that you know, if you accept their flexible working request, you won't be able to give them that proper performance management, and their performance will suffer. An insufficiency of work during the periods the employee proposes to work. So again, you know, if you've got your core hours that you need covering and they want to just work earlier in the morning or in the evening when you simply don't have the work demands. Or planned structural changes. So this is the only one that might apply in terms of the current snapshot of your business. If you know that as an organisation, you're imminently due to have a reorganisation or some form of structural change, which will mean that very soon any request will no longer be practical, you can rely on that to turn it down. But they are your 8 reasons that you have, and you do need to make sure that you're ticking at least one of those boxes if you are going to turn a request down. Ideally, I always like to tick at least 2 or 3 and be able to justify them, because then it does show that if one of them is particularly strongly challenged, you have got another reason as a backup, obviously as long as they're valid reasons. Importantly though, what does not fall within a valid reason is simply discouraging other employees from making flexible working requests. That's not a permitted ground to refuse a particular request. So it's always a bit difficult when an employer says, oh, well, I want to say no to Sarah in terms of flexible working, because there'll be 5 others that come up behind her and put in exactly the same request, and I simply don't want to kind of open up the floodgates. That is not a lawful reason in terms of turning down a flexible working request. It's understandable, but it's not one of the reasons that you can look to rely on. You need to assess your organisation at the time for that particular request and see whether it is something that can be accommodated in practice. It might well be that you can say yes to the first individual, but then no to the second or third, because your scope for offering flexibility obviously reduces the more that you agree to flexible working requests. So that can be perfectly justifiable, but saying no to the first person because you're worried about the second and third person coming down the line isn't a good enough reason. And behind all of this, whether it's informal or formal flexible working requests that comes in, do just remember that you've got overarching employment law obligations that always need to be complied with. So you've got a duty, a general duty to act reasonably towards your employees. And if you're not, and you're sort of manifestly failing to do that, it could give rise to a constructive dismissal scenario if the employee has 2 years service or not. Because obviously a duty of mutual trust and confidence, you need to be complying with that at all times. And if you're simply dismissing a request, whether it's informal or formal, in an unreasonable manner, that could potentially breach that duty of mutual trust and confidence. And also, again, your kind of base duty in terms of not discriminating against your employees on the grounds of protected characteristic. So where I find employers sometimes come a little bit unstuck on that is where they get a request from a disabled employee and they treat it in line with any other request. They're very careful in terms of following the statutory regime, etc., but they're forgetting that they've still got this additional duty to make reasonable adjustments, which might well mean that they should be going further in terms of accommodation requests if it is submitted as a request for a reasonable adjustment. So do make sure that you're not falling foul of any of your separate duties under the Equality Act by sticking too closely to the statutory regime. If it is a request from a disabled employee, that duty to make reasonable adjustments is over and above any just general duty to act reasonably that you might have. So, Tom, if you could just pop the next slide on, just moving on specifically to home working. I'm just going to touch on this briefly, and then Toby's going to go into a little bit more detail about some of the other topics. But home working, we do occasionally get asked this question, is just a form of flexible working request. So again, the request to work from home, whether part-time or full-time, is a form of any other, should be treated in some ways in line with any other flexible working application, and particular needs to comply with the statutory regime that I've just been talking about. But I think certainly for many employers, it's perhaps the most pertinent form of flexible working that they're dealing with at the moment, simply because you'll have had such a large body of your employees who are suddenly working from home. Maybe you've never had home working in the past, or just on a very ad hoc basis, and you've had this extended period of home working. Since the start of August, the government guidance has changed slightly in terms of employees working from the office or going back into an organisation. And there's more support for employers being able to encourage their employees to get back to the workplace, whereas previously the message was work from home if you can. And I think some employers are now faced with employees who are saying, well, hang on a second, I've been working from home for the last 4 or 5 months. It's been absolutely fine. I don't see why we can't just continue with this arrangement. So again, what do you do if you are faced with those form of challenges, or just requests in terms of continuing to work from home? Well, many employers in practice have chosen to adopt a separate home working policy, which they operate alongside their flexible working policy. This can be really useful, as it allows the employer to set out in more detail how it will specifically deal with home working requests, obviously again within the statutory framework I've just been talking about. And if an employee is going to be permitted to work from home, what the employer's expectations will be, because there are additional factors that you will need to take into account. So just a couple of those specific considerations, so over and above other flexible working requests, that you should be bearing in mind. Firstly, health and safety. So under the Health and Safety at Work Act, employers have a legal duty to ensure their employees' welfare, health and safety, and that applies to all employees so far as is reasonably practicable. So this applies to both employees in the workplace and those working from home. And I think sometimes employees working from home can be a little bit out of sight, out of mind, but you've got the same obligations in terms of health and safety that you would have if they were within your office environment in that respect. Employers should be carrying out a suitable and sufficient risk assessment of all the work activities carried out by employees to identify hazards and assess the degree of risk. Now, clearly that's very difficult to do at the moment, and perhaps is something that's just not that practical in any event. But what many employers are choosing to do is to send out a self-assessment, risk assessment to employees, so that they are coming back with the information about any potential risks that the employer can then take into account in terms of how to mitigate that. A couple of points that should be included on that sometimes are missed off. Employee welfare and stress. I mean, obviously that's a hot topic at the moment. It's something that should be very much borne in mind by employers if you are allowing your employees to work from home. I mean, I think we've all experienced this to a certain extent, but many home workers have found and continue to find difficulty enforcing boundaries between work and home life, and that can lead to an increased risk of stress arising from work. Employees can become isolated and perhaps lack the support network available to those who work within an office building or within the organisation. So it is important to be aware of this issue, your continuing duty of employee toward supporting employee welfare, and considering steps to monitor work and stress levels and try to integrate the home workers into the team where possible. So for example, how to do that in practice? Well, clear reporting lines should be established, so there's someone available all times should the employee have any problems, or or simply wish to pick up the phone, because you don't get those moments at the coffee machine where you just have a 2-minute chat with someone. So it's trying to translate that into a different world where people are geographically located in different places. Arranging regular reviews of the arrangement, so that should also include an assessment of the employee's well-being as part of that review process. Making sure that you're touching base with them regularly, whether it's via video conference or telephone, both in an informal way, in terms of work updates, but also informally and just checking how they're doing. So it's just bearing in mind that employers continue to have that statutory duty to ensure their employees' well-being, and that applies just as much to those who are working from home as those who are working in the workplace. And then equipment. There's often some confusion from employers in terms of what equipment they should be providing to employees and what health and safety obligations arise from that. It's going to be very fact specific in terms of what, if any, equipment you should be providing. Obviously, it's quite common to provide a laptop or a work phone, but that's going to very much depend on the specific role that the employee is carrying out. And that's the kind of detail that you can be setting out in a policy that sort of sits alongside the process. Any equipment that you are providing, though, must be suitable for its purpose and maintained in good working order. And again, that health and safety obligation lies on the employer, not the employee. But as I said, what, if any, equipment you do have to provide will depend on the role of the employee. And just going back to what I touched on earlier in terms of reasonable adjustment, again, that's a continuing obligation. It's always there. So for employees, for any of your disabled employees, you may be expected to provide specialist equipment to facilitate home working. So if you have that specialist equipment that they had perhaps in the office, a reasonable adjustment might well be to provide that in the home as well. And that's a conversation you should be having with your employees. And then just finally, before I hand you over to Toby, performance considerations. In practice, this can cause headaches. Sometimes both the employer and the employee, in terms of monitoring performance dipping, home working, or it can be something that certainly employers worry about for a continued period of home working, that people aren't going to maintain the performance that they would if they were sat in an office environment. So at the outset of the home working arrangements, again, it's all about communication. So employers should set out clear expectations of the employee in terms of performance, and ensure that the employee fully understands these. Again, helpful to do it in a policy if you can. This may include discussing and setting out expectations regarding issues such as productivity, taking breaks, what to do if the employee becomes sick, and rules around confidentiality and data security, which Toby will talk about a bit more. But it's just keeping that agreement under review and making it clear that should the employee fail to meet these expectations, which the right to work from home is caveated upon, then the home working arrangement may be terminated and they may be asked to return to the workplace at that time. So it's having clarity in relation to those expectations. Toby is going to talk to you a bit more specifically about confidentiality and data protection now.
Amazing, thanks, Lil. Yes. So my part of this talk is going to be touching on confidentiality and data protection. So I'm going to start off by saying that there's a whopping great tractor that's going on outside my window. So if I have to dash out to shut the window, I will do so. The problem is I'm wearing shorts, so it's really gonna breach the professionalism that I've got from this top down. So I've been loath to go and do it this far. I'm going to start off my part of the talk by saying that I absolutely love home working agreements. I think that they are possibly the best way that you can have a guaranteed arrangement with your employees about the steps that they're going to take whilst they're home working. Now, the reason for that, it's not just for what Lil said, performance concerns, well-being issues, how you structure their work with them on a daily basis. It also leads in to this tractor man. Look at me all morning. Anyway, it also leads in to what you do with really sensitive, confidential or commercial information that your business uses. So most businesses are going to consider that information is key. The way in which they perform their goods or their services, that's going to be the essence of their business. But a lot of businesses will also trade quite specifically on their customers and client lists. It's that element of it that's going to be completely confidential. It's obvious when someone's in the office what's confidential. It's either it's kept securely, it's kept remotely, it's kept by someone who is of a sufficient seniority. But when people start bleeding out of the office and doing much more home working, it can be very difficult for an employer to maintain that confidentiality over that information without having some specific structures in place. We all started off when we started home working, as far as we could home work, and there was just this massive leaching, of confidential information out towards employees so they could actually perform their job roles. And me, as an employment lawyer, I'm sure Lil did this as well, we had a collective shiver, because as soon as you lose that information from a secure system, you lose where it's going, you lose the trackability of it, and that can lead to issues with employees seeking to compete against you, or on the lesser end of the scale, just losing it. Probably not leaving it on the bus because there's no one on the buses anymore, but leaving it somewhere, going to a park or something and just bopping it down, or someone coming into their home, friends or family that they might trust. We have no idea who they actually are, but then they look over their workspace, and if their workspace is the kitchen table, that's not keeping things confidential. But employees often just don't know that. We have this issue with people where I had a disciplinary hearing with an employee recently for this exact reason. She'd taken a lot of information home with her. She would do it on the kitchen table. Someone from a competitive business had come into her home. It was just one of her friends, had seen the information. We had no idea if that information is going to be used against us or what they did with it, but it's her fault. Now, her outcome was, I didn't do that maliciously. I was simply trying to do my job. And quite right too. Completely failed for her. But what that business had done is they'd taken our advice at the start and they put in a very specific home working agreement. So you have a policy about how you would grant home working and the key issues that you have with that, and that's probably for the future. And then you've got anyone who is home working, how they will perform that role, how are they going to maintain confidentiality whilst they are working from home. And there's a couple of key steps to it. So you've got to tell them. You've got to tell them to make sure that they're aware of their obligations and what steps they need to take. And then we differentiate between different aspects of their business. So we have things that are core, key, trade secrets, customer lists, supplier information, key contacts. We say to these people, these are level one. These are red light, level 1, we need to keep these completely confidential from anybody, but this is how we're going to do that. And then we set out steps for those people within those home working arrangements about what they're going to do. So information that's stored electronically, never leave an electronic device unattended or lock it when you do. Don't disclose your passwords to anyone. And I always put at the end of it, even if asked to. Even if someone asks you for your password, don't tell them. Don't store any confidential information on a personal device. And also report any suspected breach of confidentiality immediately, as soon as it happens. Now, we as a business, we can put in place remote locking systems, password managers. So if we think anything might be under threat or anything might have been lost, we can then securely remove it or delete it or lock it again. Those are grand. Those are great ways of doing it, as long as everyone is following that process. You can have this lockbox system that people can use to store information. If that person then, because it's a little bit easier, copies that, puts it onto their desktop, we can't then remotely access it. We can't then remotely delete it. We have to have some sort of reprisal against that employee, at very least, to sort of retrain them on what steps they need to be taking. Hard copy documents, that's been a good one. I've had quite a few employees who have popped in to offices to print off hard copy documents and then take them home. And those hard copy documents have contained confidential information. Now, we didn't know about that until someone had said, hang on, I saw Jim carrying a big stack of documents out, but then when he went, we had no idea what were on them. But again, he didn't believe that he was doing anything wrong. He just didn't want to read that on his screen anymore. He felt he wasn't as effective as a worker if he was reading that whilst he was at home. But those hard copy documents, they cause us an issue, because again, what to do? How do we make sure that those are securely and safely destroyed when they're not being in use? That's where home working agreements come in. We say to people, if you're going to have hard copy documents, you need to tell us what they are, what you need them for. And that could be a dead simple email just saying, I've got to have a client list so I can contact the clients. Perfectly reasonable, brilliant. We want you to be able to contact clients to do your job. But we want to know what's happening to that. Do we mark that with a confidential number and say that as long as when we get this document back, it's still got that number on it, it is one of a number of copies, we know exactly where it is, so that we have track and traceability on that. And some businesses took this on at the very, very start and have put those systems in place. Other businesses, you're coping with the fact that lockdowns occurred, you're coping with the impact that coronavirus has had. It's now that we need to start looking at putting those formalised home working agreements in place. As Lil said, you're going to start seeing a lot more flexible working requests. Even if it is informal, formal, whatever it might be, you are going to see a lot more people who do want to work from home. So having that forethought to, what am I going to do with this? How am I going to manage that? And then whacking it down in a document means that no one can have any disagreement about what their obligations were. I love them. I think they're great, and they're definitely worth the time putting them in. And they sit alongside a contract of employment. You can literally just pull them out whenever any individual wants to do home working now or in the future. So just click on to the next slide, please, Dom. So my next one is everyone's favourite topic. Oh, one back. Everyone's favourite topic, data protection. So again, it's probably unlikely that at the start of lockdown, your first thought when you came to log on and the first time from working from home was, what should I do about my data protection obligations? What about the Data Protection Act 2018? What about GDPR? So incredibly unlikely you would have thought about it. But the Data Protection Act still exists. GDPR still exists. We as businesses are still having to comply with it. And there are key and core obligations that a lot of businesses have missed. Now, the ICO, so the Information Commissioner's Office, has said that they won't take remedial action, or they won't take harsh punitive action against businesses who, by the fact of coronavirus, somewhat miss some of their data protection obligations. That's all well and good, but the ICO are the enforcement body for data protection. So they're the initial people who get the report and then decide what to do, and it might be a fine, etc. They're not a court. So whilst they might say, yeah, okay, don't worry about it, it might be a little slap on the wrist and we'll tell you what to do and we'll have that sort of coaching element to it, the law's still there. The law still says you have to do these key things. If you don't do them, someone sues you for them. You saying, but the ICO didn't really care about it at the time, won't carry any muster. What it'll be is, there was a breach. What is the outcome of that breach? What should it be going on for? So again, these are the steps you've got to be putting in place now in order to work out with those employees what they should be doing whilst they are working from home, First one, training. Training is by far the best way to ensure that individuals know about their obligations. You know, we have to do that anyway. It's a core requirement of the Data Protection Act for us to train our employees. There is now specific obligations as arises home working to make sure that those individuals don't breach data protection rules whilst they are home working as well. So if you've had training already done in your business a couple of years ago when GDPR came in, you need to be refreshing that and adding a course into it for home working, just to simply say how you keep those bits safe, how you're going to trade with people's information. If you are working from home, what happens when a client calls you and there's somebody else in the room and you're using their name or their other confidential information or their data protected information? You know, those are all structured in. You know, we can take a pragmatic and a practical approach to it. If you don't have that training in place at all, you're going to be, it's definitely worthwhile in putting that in. The second part is what's called a data privacy impact assessment, so DPA. Now, these are issues of risk assessments. They are, as you would do for health and safety, as you're required to health and safety, know about that aspect of it. You're required to do data privacy. So you're looking at what the impact of this new system of working is going to have on the data of individuals and their privacy and how you're going to protect that. Now, you do that by running through what can only be described as a whopping great form. It's this massive form that you have to run through. You go through, well, look, we've now got home working, we've got people working from home. What's going to happen? Who's going to access that information? What happens if they leave it unattended? Where are those papers going to be kept? How many things are going to be moved between home and the office? Have we given them guidance about the transfer? What measures are going to be put in place? Are there going to be outcomes for them? And it feeds in, it's this huge sort of schedule to go through. We decide what key steps are going to be, and then you take remedial action once you've identified those risks. You cannot do that in your head. You have to put it down on paper, and it is for any potential change. So the normal course of events would have been if you put a new computer system in place, you do DPIA, you do an assessment to see whether or not it's going to impact on privacy. In this respect, people working from home or people doing more remote working, that requires you to do DPIA. They are deep because they're big, but actually, to them, the contents of it is fairly practical, but you have to have one on file. And the other issue that I've come across really recently, employees using their own devices. So systems are not working correctly. Someone has given a phone because they're working from home and they don't normally need to contact customers, and then they're just using that information. You know, they're using their personal devices to contact people, either to circumvent a system or just to try to do their job a bit better. You know, that we can do that practically, be pragmatic about it, but we need to know what their passwords are. We need to make sure they're using multi-factor authentication for any of their passwords. They need to make sure that operating systems are up to date. They need to understand how to internally report those issues as well. Where can we put all of those things? Home working agreement, yay! That's exactly what we do. You know, you bring it all in together, you pull it all into one solid codified document, tell people exactly what to do in the home working, what we think is important. Here's our confidential information. This is what we also think is important, the data protection information. This is what you need to do. And it's all written out, everyone's happy, and I'm happy, you're happy, and it all works very, very well. So you'll be glad to hear that that's the final part for me on data protection. So I'm going to kick over to the inimitable Emma Noble, our partner for this webinar from Elevation Recruitment.
Morning, everybody. Just a quick introduction. So Elevation Recruitment Group is a multi-specialist recruitment business based out of 2 offices in Yorkshire. Because we are multidisciplined, we are able to offer our clients an opportunity to be their exclusive recruitment partner across all business functions, which plays a really positive role in the efficiency of their recruitment process. Our specialist disciplines are accountancy and finance, engineering and manufacturing, sales and marketing, HR, business support, procurement and supply chain, and Parkinson Lee, our executive search business. I'm the ops director for the group. I've got over 20 years experience of recruiting for senior HR and finance positions in the Yorkshire region. Next slide, please, Tom. So the first thing that I'm going to talk about is what to consider when you're hiring a remote worker, because there is a difference in terms of the recruitment process that you need to consider when you're hiring remotely, but also thinking about the type of individual that you're going to recruit that's going to sit and work for you remotely as well. Collaborative hiring should be a priority for hiring someone who is going to be remotely working for you. So future teammates will have the opportunity to assess, evaluate and get to know potential remote hires in the recruitment process. This is going to really help you ensure that the remote hire is a good skill fit, in addition to a cultural fit for their potential team. So just make sure that your technology can accommodate multiple users and facilitates team interviewing. Customize your question set. So you will have standard screening and culture fit questions, but there are a few additional questions that you may want to add for remote candidates. Think about your ideal remote worker and how they manage to work remotely. There are a couple of core competencies that you will want to look for example, time management, discipline, communication, consistency, proactivity, amongst other things that are relative for your business. Remember that you are looking for a different kind of profile, and sometimes people forget that remote employees require a different set of skills and even personality traits. So your candidates will need to know how to work remotely effectively. In terms of interviewing, so we've supported a lot of clients in the last few months with remote interviewing, and we have now collected a lot of feedback on this, and it is a really different process. And some of the clients that we've worked with haven't considered this, so this is really important. Preparation is absolutely key for your remote interviewing. So when you send the invite to the candidate, make sure that you give them plenty of information to prep, and you can also help them start to get a feel for the company. So you can ask them to test the link before the meeting, make sure that you've got the candidate's mobile number, that they've got yours in case of any technology issues. Give them a picture of the company, so you can actually put this on the diary invite that you send to them. For example, why don't you take a look at our website and our opportunities? Here's a virtual tour of our offices or plant or site. Show content that gives them a glimpse into your culture and lets it shine. For example, if you've got a YouTube channel, an Instagram page, or you've got a Glassdoor page, anything like that. If the interview is involving multiple people, choreograph that, script that carefully. We've had quite a lot of feedback from candidates that have said it was a multiple interview, but somebody was sat there not speaking for the whole interview, and that person, they are going to be working with that person, and it did put them off. So just really think about that. So if you're leading a hiring team, make sure that they've got the tools and the training to make sure that the remote interview process goes well. The experience of an interview, particularly when there's not a chance of going to the actual workplace for the candidate, it really does count tremendously. If the interview is mediocre, awkward, a bit tedious, this will transmit the message to the candidate that the work culture at this prospective employer is lacking. Remote interviewing does feel very, very different from in person, and I can't stress that enough. And like I've said before, there has been a lot of feedback on this where the candidates have said to us, I just didn't feel engaged at all, and it's put them off. So as the interviewer, you need to make it as comfortable as possible. Without the natural flow and physical reminders of an in-person interview, it's really easy to forget the small things that would make a remote interview just as comfortable as coming into the office. So make sure that the set is dressed so that the background isn't cluttered. Make sure that the interviewer is appropriately dressed. Be the first to show up. So really put your candidates at ease by being present when they actually join the virtual room. Ideally, take your notes on paper so that you're not typing while the person is talking. If you are going to be taking notes on the PC, just let them know that you're going to be typing during the interview. And in this scenario, it's best to put yourself on mute so that you're not typing in their ears as they're speaking. But you'll need to keep in mind that for them, it's going to feel like they're talking to a silent crowd. In terms of don't lose the small talk that you would normally have with candidates in person, and be overly expressive. interviews are extra stressful when it's really hard to read the body language. And again, this is a big point that has come out over the last few months. Nodding, smiling, laughing, helping make the situation more comfortable for your candidates is really important. It's really good video etiquette to maintain eye contact, not a glassed out stare, but just looking at the face of the person that you're interviewing, transmitting your reactions really, really clearly. Focus on the person that you're interviewing, not the screen or the settings. So this is another really good reason to have your technology well rehearsed. Body language is more obvious in this virtual environment, and so is your intonation. So it's very important to come across as human, but obviously be polished. And make sure that you provide time for the candidates' questions, answer them thoughtfully. If you've got to get back to them, do it in a timely fashion. Technology issues. So how to deal with this during the interview. So technology issues can happen. So if you're in doubt and it's just not happening, just leave and rejoin the meeting. If that doesn't work, then I would just give the candidate a call. If the issue is Wi-Fi connectivity, just suggest that the candidate moves closer to the Wi-Fi router if they're able to do that. The second step would be to turn off the video and attempt to communicate just over audio. And then the third and final step would be to switch the call to take place over the phone. If it's going to take more than 5 minutes to sort out your tech issues, I would just reschedule it for a later time. So just be prepared for that to happen. Make sure that you've got a plan B. So Tom, if you can just move to the next slide. In terms of feedback, so just make sure that there's a really clear way for candidates to follow up with you. Your candidates and interviewers can offer critical feedback to help you strengthen your process over time. So continue to collect feedback from both sides, use it to improve your virtual experience. And then once you've got your employee and they're onboarded, ask them the value that they got from your onboarding strategy. By constantly evaluating and improving the onboarding process, you can help remote workers adjust to their new roles easily and refine for future remote hires. In terms of onboarding remote workers, use video conferencing and internal messaging software to introduce your new hire to co-workers. This allows new hires to feel more comfortable in conversations that are going to create personal bonds. Video conferencing allows employees to make eye contact, observe facial expressions that are important to interpersonal communication. Virtual tours, so if you have already got images or videos from inside your offices or plant, you can prepare virtual tours that give remote workers a sense of the company environment. A virtual walkthrough that allows remote workers to see co-workers in action. Even if it's not a current video, it just might still help to reduce feelings of isolation. Set expectations. So I think this has already been mentioned in terms of clearly communicating your expectations to new employees before they start work. Onboarding employees with a clear picture of their duties is the basis for successful hires. Both you and the remote workers should be clear on company values, team objectives, individual goals, and you should also establish timeframes for training, reviews, and milestones. You should verify that new employees understand their tasks and the systems that they'll use in their work, discuss upcoming projects, and access to shared employee resources. And making them feel welcome. So in terms of that sort of 0 to 3 months where we've had a lot of feedback that it's been really weird for new employees being onboarded remotely. And this is a critical time of when they might leave if they don't feel welcome into the business. So it's really important that they become a functional part of the team, introducing them to other team members, where to turn to help, build relationships that are important to job satisfaction and importance. Ensure the rest of the team is accepting of the new hire. So connect the new employee with a veteran team member in a mentored relationship to better understand business goals and values. And make sure that you provide the right tools for remote working, i.e. desk, chair, laptop, etc. Just make sure that you understand the employee's home environment to ensure that they are comfortable and will be as productive as possible. In terms of ourselves, I mean, we've worked with multiple businesses across the region, supporting them through the pandemic and remote interviewing. We've provided insight on the best interviewing technologies, the best interview techniques, how virtual interviewing has affected candidate attraction. We've sat in interviews with hiring managers to help control the format or just provide support to them with questions. We've provided feedback on the pros and cons of your own interview style and giving you feedback from the candidates. So anything that you need help or guidance on this area, just let me know. And back over to Freeths.
That was brilliant. Thank you, Emma. Lots of great tips. So presuming that we've followed all of those great tips, we'll be looking to recruit, and I'm essentially going to take us through the next stage in that process. So I'll just be talking through right to work checks. I'll be looking at temporary changes that have been brought in response to the COVID lockdown, and then I'll just run through a couple of the digital online right to work options that were already in place, but you may not necessarily be using them. So I just wanted to highlight those to you. Just a quick reminder, if you do have questions, we will have time after my section now to answer those. So do please feel free to use the question and answer box, post those, and we'll run through as many as we can. Okay, so as you might imagine, as a result of the lockdown, right to work checks have been temporarily adjusted. Now, it's important to remember that they have not been suspended. They continue to be as necessary as ever. Failure to complete proper right to work checks, which potentially results in the employment of an illegal worker, still carries exactly the same civil penalty. There's been no change to the acceptable documents for a right to work check. Those are exactly the same as set out in the existing right to work check policy guidance. The changes really have been to process. So whereas previously a check had to be undertaken face-to-face, it can now be carried out in a video call, and previously you would have needed to have had sight of an original document, whereas now a scanned document is acceptable. So if you are going to follow this process, essentially you'll be asking the prospective employee or existing employee who has only had a time-limited right to work check undertaken previously to send you a scanned copy of their document. So that will be the document as prescribed by the right to work check policy document. You will then arrange a video call with them, and during that call you need to ask them to hold up the document, and then you'll check that carefully against the scanned copy that you've received. Now, you need to pay particular attention to a photograph in a document if it is one that contains a photograph, such as a passport or a biometric residence permit, and you need to just check that that photograph is a reasonable likeness of the person that you can see on the video screen, just to check that the document that they're holding up and the document that they've sent you is likely to be a document that's held by them. Once you're satisfied that you've seen an acceptable document, you would then save a scanned copy, the scanned copy of the document that you've received. And on that, you need to record the date that you made the check, and the recommended wording within the temporary policy is that you mark it to say adjusted check undertaken on, pop the date in there, and then the words due to COVID-19. Now, the important thing to remember is that that isn't the end of the story necessarily. So if you have undertaken these checks for people you've recruited during this lockdown period and during the time that this temporary policy is in place, or if you've undertaken a repeat check on an existing employee who had a time-limited right to work check undertaken previously, then you need to keep an eye on the guidance, because when this temporary guidance comes to an end and normal circumstances are resumed, there will be then new policy guidance in place at the time. And at that point, you are expected to do a repeat check. This is considered to be a retrospective check because it will be a repeat check that's being undertaken after employment has started. And that repeat check will need to be in accordance with whatever the policy says at the time. So if the policy goes back to pre-COVID policy, and if it says face-to-face must be original documents, then that's the process that has to be followed. And then on that repeat check, the recommended wording on the document, the saved document that you will be retaining for your files, is the individual's contract commenced on, and you pop the date in there. The prescribed right to work check was undertaken on, pop the date in, due to COVID-19. And then you have to maintain both of those documents to have an ongoing statutory excuse against a civil penalty for right to work infringement. Now, of course, at the point on which you undertake that repeat check, if it then turns out, or if you're not satisfied that the original document that you now have sight of is a genuine document, if it turns out the person doesn't actually have a right to work, you would need to end employment at the time. And if you ended employment at the time, then you wouldn't be liable for a civil penalty for right to work infringement. Now, there are a couple of online services available, and the first one will be becoming more and more relevant, and it may be that you opt, where you can, to use this rather than use the temporary policy that I've just run through. And the reason for that is that if you were using the online right to work checking service, there would be no need to then repeat a check and do a retrospective check. So you could just be satisfied then that your right to work compliance was all in order. So the online right to work checking service actually launched 2 years ago and was fully implemented in December 2018. But at the time it was only in use for prospective employees or existing employees with time limited right to work who had a biometric residence permit or a biometric residence card. But it's now been rolled out also for employees, prospective employees who have status under the EU settlement scheme. So this is why it will be becoming more and more relevant, because you'll be coming across new people, new employees who have status under the settlement scheme, as over 3 million people have now applied for that status. So there's a slightly different process depending on which group of people they fall into. So if they hold a biometric residence permit or biometric residence card, they need to give you permission to access their online record, and they need to give you their residence card number. You'll still be wanting to have a look at that card, so a scanned copy of the card, and you'll still be wanting to be satisfied that that does genuinely belong to the person that's presenting it by comparing the photograph on the card. You then use the online checking service, and that then gives you just real-time information about their immigration status. And from there, you can then download a PDF of that record. The date on which the check was carried out is automatically recorded by the system, but it may also be prudent for you to also record the date on which you carried out the check. And then there's nothing else that you need to do. That is your right to work check completed. Now, if they have status under the EU settlement scheme, it only differs slightly because it's just a different portal that you're accessing essentially in order to view their status, and they need to take a proactive step first. So they will have access to their portal, they need to access it, obtain a share code, give you the share code, and then you use that share code to have temporary access to their portal. And within there, you will find a photograph of them so that you can then have a video call, compare the photograph to their likeness to make sure that it is the person for whom you've been given access to the record, and it will confirm their immigration status. So it will say either that they have indefinite leave, no time limit on their right to work, or limited leave, and it will give you that time limit. And again, then that's the check completed, again, unless of course it's time limited leave, at which point you would do a repeat check prior to expiry. Now, there will be circumstances where an existing employee who had time limited permission to work, or a new employee cannot provide you with any of the acceptable documents, because they'll be saying, well, actually, I've submitted an application to the Home Office to extend my permission, and potentially my documents have gone off to the Home Office, and so I can't provide you with them at the moment. In those circumstances, you would use, again, an online system, but it's the employer checking service. So in a situation where you have seen some information, for example, an acknowledgement from the Home Office that satisfies you that an in-time application has indeed been made, so you know when their leave expires and you have an acknowledgement that predates that, then you have a 28-day grace period in which to use the employer checking service. It's usually advisable to wait about 14 days because it does take the Home Office a while just to update their records, and it just saves you receiving an indeterminate result, which you then need to repeat. So you'd wait about 14 days, you'd then submit your employer checking service application. That takes 5 days to come back. And then you'll receive either a positive or a negative verification notice. And really, there, as they say, positive is green light for go, so you can employ the person, but it's only valid for 6 months. So you'd be diarising to either repeat at the 6-month point, or by that time you would have received confirmation of the person's permission and right to work, or it's negative. And if it's negative, you can repeat as many times as you need within the 28-day grace period. But if you don't receive a positive check by the end of that grace period, then you would be declining to employ, or if they're an existing employee, you'd be looking to end their employment. So I think the use really, particularly of that central right to work checking service, the second one that I ran through, will become much more relevant, as I say, as we move towards the end of free movement, and we reach the end of free movement at the end of this year. We'll be seeing many more people who will have this type of online status, and the Home Office are running a full digitisation programme, so we'll see much more use of online status. But in the meantime, those temporary measures that I set out at the beginning should provide just an easier mechanism for the short term in terms of being able to undertake those right to work checks. So that's it for me. I'm going to hand back to Lil just to wrap everything up for us, but I'll say thank you very much for joining us this morning, and I hope the things that we've all covered, Lil, Toby and Emma and myself, have been useful for you. Thank you.
That was great, Emma. Thank you. Really informative. So that's the perfect timing in terms of bringing us up to 11 o'clock. We do have some time for questions, and we had a few that have come in separately that I just want to run through. Firstly, before I do that though, apologies for the crackles right at the start. It was certainly a bit crackly at my end, and I think it was for a number of you. If any of us were saying anything that got missed by crackles, the joys of technology, do feel free just to drop us an email and we can cover off any points that you did miss, but hopefully the vast majority was quite clear when it came through. So as I said, we've had a few questions that come through separately. So the first one is for Emma Noble. So a practical question, how would we go about making sure our staff or new hires can work remotely?
Sorry, can you just repeat that?
So how would we go about making sure our staff or new hires can work remotely in practice? I suppose, what should you be checking that they can have in place?
Yeah, I think what we've been working with clients on is, you know, have they got a desk? You know, have they got the right equipment to be able to work remotely? Is the line manager able to communicate with a member of staff on a daily basis? Is everybody clear on the, you know, the work that the remote employee is doing? So I think it's probably worth just putting together a checklist that you agree with your team and with the company in terms of what everybody wants the remote worker to do, and then working with the remote worker to make sure that they've got everything that they need, because sometimes what we've found is that some potential employees, for example, don't have access to a desk or somewhere where they can sit properly. So we had one case where they were actually sat on the bed, you know, because they were sharing a house with somebody. So obviously for a temporary measure for a couple of days, that's fine. But long term, from, I think you mentioned before, from a health and safety perspective, that wouldn't work. So it's just making sure that those things are happening, really.
Yeah, okay, thank you. We've had a few come in for Emma Brooksbank. First one has just arrived, so I'll pick that one off first. If an employee leaves during the temporary COVID-19 measures and we only have an adjusted check done by a video call, would we still need to do a repeat check with an 8 weeks notice of the temporary measures ending if this employee has left and no longer works for us?
Yeah, so the answer is no. You wouldn't. I mean, you can imagine the practical challenges you would have in terms of that repeat check. You would just want your HR record to clearly indicate the date on which the employee left employment, so that if you were ever asked for an audit trail, you would be able to show that you undertook the proper check in place in accordance with guidance at the time, and that would be perfectly satisfactory.
Great, thank you. And just sticking with you, sorry, I've got two more for you, Emma. Are we liable if the employee sends us a fake scan of their right to work documentation?
Yeah, so this is essentially in line with the existing policy. You as employers are not expected to be forgery detection experts. You are only expected to be able to identify a forgery if it would be easily identifiable to a reasonable but unqualified person reviewing that document. So if somebody sends you a scanned copy document and it turns out later that that's a false document, but it is not obvious on the face of it that it's false, then no, you are not liable.
Okay, because you see as airport security, they seem to almost do some mini measurements of faces and things, don't they? So I suppose it's just how far you have to go.
No, we're not expected to have any specialist equipment or any special expertise. We do, though, need to do these reasonable checks. So you would, for instance, with a biometric residence permit, you'd look at the date of birth and say, okay, is that, you know, is that likely? You would check the photograph and make sure that it's a likeness, but of course you're not expected to be able to carefully analyse whether it's an exact match. You just need to have undertaken a reasonable check and cross-reference against the person that's presenting themselves in the video call and the document that they're giving you.
Okay, and sorry, just one more for you, Emma. What's the potential fine for a right to work infringement?
Yeah, so it's up to £20,000, but you have an almost immediate £5,000 reduction if you haven't had any infringements previously. You can then reduce by a further £5,000 if, for example, you cooperate with the Home Office. So if, for example, it was you that discovered on that retrospective check that actually it's a false document and you reported that to the Home Office, or if you're just cooperative with their inquiries, then you're quite likely to get down to 10,000, but that's per employee. So in sectors where you have high turnover and high risk employees, you know, it can rack up, so it isn't a risk really worth taking.
Yeah, no, it's expensive. And then one for Emma Noble. What key skills do you think managers need in order to manage a remote team if they've not done this before? And then following on from that, what support might be helpful from the business for those managers?
Key skills and support. I think that one of them is the communication. So what we've found is that a lot of businesses that we've worked with have never done remote working before, so it was a complete and utter change for them. And the ones that seem to have done it successfully and are continuing to do it successfully is where there has been a lot of collaboration with the line managers, where there's been a very strong objective set for the line managers, in the sense of this is what we want out of the remote workers, and supporting those line managers in terms of this is how you need to communicate, this is the technology that you need to use, and just agreeing really as a management team, you know, what you want out of those people. So I think the ones that we've seen have struggled is where there's been maybe a lack of trust in terms of the remote workers, and there always is that element with it where it's like, what is that person doing? But if you've got clear objectives for everybody, and the line managers understand that, and then they can communicate that to the remote workers, that does seem to work much better. But it is a learning curve for everybody. So I think in terms of the support that you can give to your teams is just to make sure that everybody is on the same page in terms of what you need out of the remote workers, like what the understanding of the flexibility is. You know, we've had quite a few clients where they've been very, very flexible with that. So it's as long as you get the work done, you can have a couple of hours off in an afternoon to homeschool your child or go to the doctors or whatever it is. You know, that does seem to work a lot better than having more rigid rules that are very difficult to manage when you've got a team of remote workers.
Okay, thank you. And then just one for Toby. If we have provisions in place, so for instance, a clear home working agreement, but a home working client deliberately breaches our data protection obligations, what's our liability?
So businesses are vicariously liable for their employees. So if something is done during the course of that person's employment that breaches data protection obligations, the employer is primarily liable. So that tempered by the fact that if they do something, sorry, I get a bit of feedback there. If there was a criminal wrongdoing, then the business can say that wasn't done and therefore they can be relieved of liability. There's this Morrison's case where the chap, he disclosed loads and loads of pension information for 8 years, and Morrison's was still found liable for it. The Supreme Court very, very recently just overturned it to say they're not liable because it wasn't during the course of his employment. So yes, but also no.
Thanks. And then just one for Emma, in terms of immigration. Is it personal or company liability when it comes to right to work checks? And would you recommend taking out individual insurances if it is personal?
Sorry, I think the question, but you have to nod or shake your head, is it company liability or personal liability? And if it's personal liability, would you advise insurance? Is that right?
Yes, it is. Sorry, I might make this the last one because it's getting very crackly, I think.
So it's company liability unless there's knowing deception, so if knowingly recruiting and employing illegal work becomes criminal liability. But if it's essentially inadvertent employment and failure to undertake an adequate right to work check, then it is the company that's liable for the civil penalty. So there's no need for personal liability insurance.
Okay, thank you. Sorry about the sound issues there, everyone, but hopefully you got the vast majority of that. So we have I think that brings us to the end of the questions that we've got already in anyway. So we'll bring it to an end because of the ongoing crackles. So thank you very much for attending. If you do, as I said, have any follow-up questions after the session or want any further information, then please just drop any of us an email. But other than that, thank you for your time this morning.
Thank you.
Thank you.
Thanks.